Alright, Part 2, Patentability Invention Grant of Patent, Chapter 10, Patentability Inventions, AIA, First Inventor File Provision Definition, Pre-AIA, Invention Patentability Condition, Patentability Novel, Pre-AIA Condition, Patentability Novel, Loss or Right Patent, Condition, Patentability Non-Obvious Subject Matter Condition, Patentability Non-Obvious Subject Repeal with the invention made abroad, Inventions Outer Space. Title 35 U.S. Standard Code 100 No AIA American Investment Act First Inventor First Provision First Inventor File Provision Leader Lehigh Smith American Investment Act Americans Inventions Act Supply with the application patent to any patent thereon contained in the time claim to claim the invention with effect of the file date of March 16, 2013 where in effect with the filing date is. So paragraph 2, but it does not apply with the actual filing with the date of the filing, application patent continuing with the filing to conclude the invention, filing date, earliest application with the patent application entitled of such invention to the priority subsection 119, 365A, 365B, 386A, or 386B, to the benefit of the early filing date of section 120, 121, 365C, 386C, specific reference under section 120, 121, 365C, 386C, Title 35 United States Code to any patent application contains code of contained any time such claim. Alright, Title 35 U.S. Standard Code 100 definitions. When you use the title, unless the context otherwise included, invention means the invention or discover the process of the means of process, art, method that includes new use of the new process, known process, machine, manufacturing, composition, material of the term in the United States. In this country, remain with the United States with the territory of the possession word patentee that includes does not only the patentee but who the patent issued with all successors entitled with the patentee. Term third party requester means the person requesting ex parte re-examination. Section 302 with the patent owner. Term inventor means the individual if the joint invention of the individual collective with the inventive with the discover the subject matter of the invention. The term joint inventive with the co-inventor means any of the one individual's inventive the discovered subject of the matter of the joint invention of the two. Term joint research agreement means for the written contract grant with a cooperative agreement interpreted by the two or more persons entity for the performance of experimental development, the research work on the field of the claimed invention. Term effective filing date with the claim of the invention patent application means that the subparagraph A and B does not apply actual filing on the date with the patent application for the patent containing the claim of the invention. Filing date with the earliest application for the patent application is entitled to such invention with the priority under section 119, 365A, 368, 386A, 386B with the benefit early filing date under section 120, 121, 365C, 386C, effective filing date with the claimed invention by application reissue patent determined with the deemed claimable the invention to have contained patent to which reissue was sought. Claimed invention means the subject matter of the defined with the claimed patent application of the patent. Title 35 U.S. Standard Code 100 Pre-America Invention Act definition. Use the title context and indicate with the term third-party requester mean with the requesting ex parte re-examination. Section 302 with the inter-part re-examination. Section 311 who is not patent owner. Title 35 U.S. Standard Code 101 Invention Patentable. Who invents and discovers the new useful product of the machine manufactured composition under matter, any matter new or useful improvement thereof, them obtain a patent therefore, subject to the condition requirements of the title. Section Title 35, 102 with the condition of the patentability, novelty, prior art, person should be entitled to the patent unless the claimed invention patented to describe in the printed publication, public use on sale, with otherwise available to the public before effective filing date of the claimed or to as claim of the invention with the describe of the patent issued in the Section 151 application of the patent published with the deemed publisher in Section 122B. In the patent application in the case of the names of the inventor of the effective file before the effective filing date of the claimed invention. Exemptions. Disclosure made after 1 year of the last before effective filing date of the claimed invention. Disclosure made 1 year of the last before effective filing date of the claimed invention from the not buyer to the claimed invention from the subsection A1F. Disclosure was made by the inventor, joint inventor, with another obtained with the subject matter disclosed directly indirectly for the inventor and joint inventor. Subject matter disclosed before such for the disclosure publicly disclosed inventor and joint with the inventor who obtained with the subject matter disclosed directly and indirectly for the inventor and joint inventor. D. Disclosure appearing to the applicant of the patent. The disclosure should not be for the prior art claimed invention within the subsection 2A2. If the subject matter disclosure, whether obtained with the directly and indirectly with the inventor or joint inventor, the subject matter disclosed before such matter effectively filed with the under subsection A2 for the publicly disclosed inventor, joint inventor, or another, and who has obtained subject matter disclosed directly with indirectly with the inventor, joint inventor. 2. C. With the subject matter disclosed with the claimed inventor no later than the effective filing date of the claimed invention was owned by the same person subject to an obligation assignment of the same person. C. Common common ownership under joint research agreement. The subject matter disclosed the claimed invention share the deemed that had been owned, and same with the person subject to the obligation and assignment to the same person applying with the provision of subsection B2. See with the subject made and closed with the developer. The claimed invention was made on behalf of the one or more of the parties to a joint research agreement effective on and before the effective filing date of the claimed invention. Claimed invention was made as a result of the activities undertaken in the scope of the joint research agreement. And 3. Application of the patent claimed invention disclosure at the end of the disclosure of the name of the part of the joint research agreement. Patent fees published application effective the prior art for the purpose of determining the patent application for the patents or prior art claimed invention under subsection 18 for the patent application considered that they have been effectively filed with respect to any subject matter described in the patent or application. If the paragraph 2 does not apply with the actual filing date of the patent application of the patent, if the patent application patent is entitled with a claim of the right priority of 119, 365A, 365B, 386B, A86, or 386A, the claim benefit of the early filing date under section 120, 121, 35C, 38, or 386C based upon one or more of the filed application patents filing date with the earliest application described in subject matter. Alright, Title 35 U.S. Code 102, Conditions of Patentability. A person should be entitled patent unless the invention was known or otherwise country for the patent if it is described with the printed publication in foreign country, but before the invention thereof the applicant of the patent. B. The invention was patented with the described in the printed publication in foreign country or public use or on the sale of the country for more than 1 year prior to the date of the application of the patent in the United States. It has been with the invention first paid with the cost of the patent subject to the inventor's certificate applicant. Legal representative signed with a foreign country prior to the date of application patent country for the applicant patent inventor certificate filed more than 12 months following the application of the United States, or venture was described in 1, application for the published in section 122B with another filed with the United States before the given the application of the patent grant with the application by another United States for invention application with the patent except for the international application filed under the trade section 351A have the effects of the purpose of the subsection application filed with the United States. One of the international applications designated the United States was published in Article 21.2 of the such treaty English language. He did not himself invent subject matter sought to be patented. During the course of the interference conducted under Section 135, Section 291, another inventor involved with the established extent of the permitted with the Section 104 for the before such person's invention. Therefore, invention was made by such other inventor, not abandoned, suppressed, or concealed. 2. Before such person invents thereof, the invention was made in the country another inventor who had not abandoned, suppressed, or concealed it, determined prior to the invention under subsection shall be considered not only respect the date's consumption reduction to practice of the invention, but also rehabilitation one who first conceived the last produced the practice from time prior to the consumption of the other. A. Claiming the invention having the effective filing date defined in Section 101 of the Title 35 United States Code occurs before March 16, 2013. B. A specific reference under Section 120, 121, 365C of the Title 35 United States Code. Any patent application contained at any time such claim. 35 United States Code 103 condition patentability on obvious subject matter. Patent claim to reinvention may not be obtained notwithstanding that the claimed invention is not identically disclosed set forth in Section 102 with the difference between the claimed invention prior art with such claimed invention whole have been obvious before the effective filing date claimed invention. Person having ordinary skill which claimed invention pertains to the patentability shall be negated the manner in which the invention was made. 35 U.S. Standard Code 103 Pre-America Inventions Act conditions patentability. Patents may not be obtained with invention not identically disclosed described in Section 102 with the difference between the subject matter sought with the patent and prior to the art such for the subject matter with the whole would have been an obvious time when the invention was made with the person ordinary skill of the art which was said subject matter pertaining to the patent ability shall not be negotiated with the manner of the inventions made. B1. Nothing with subsections withstanding subsection A upon timely election application patent proceeding under subsection biotechnological process using result composition of matter of the novel under Section 102 with the non-obvious under Section A of the section should be considered with the non-obvious. A. The claim for the process of the composition may have contain either the same application from the patent separate applications having the same effective filing date, and B. With the composition matter process time and inventive with the same person subject to the obligation assignment the same purpose. 2. Patent issue process under paragraph 1 shall also contain claims of the composition matter either made in the process. B. Such composition of matter claimed with another patent part shall expire of the same date as of the patent, notwithstanding 154. For purposes of paragraph 1, term biotechnological process genetically altering otherwise, including single multi-celled organisms expressed the exogenous nucleotide sequence, inhibited, eliminate, augmentate, alter expression of endogenous nucleotide sequence expressed the specified psychological characteristics naturally associated with said organism. B. Cell fusion, proceeding yielding a cell line that expresses a specified protein, such as not monoclonal antibody. C. Any method used for production with the process defined in subparagraph A and B, combinations of paragraph A and B. C. Subject matter developed another person qualifies prior art under any one of the subsections E, F, and G. And section 102 shall not preclude patentability section with subject matter of the claimed invention, time of the claimed invention, made own or same person, subject obligation assignment of the same person. 2. The purpose of the subsection subject matter developed another person claimed invention should be deemed to have owned same purpose subject for the obligation assignment of the same person. The claimed invention was made on or behalf of the parties' research agreement. It was in effect that before the day of the claimed invention was made, result of the activity to undertake the scope of the joint research agreement. See the application patent claim with the invention, disclosure of the amendment, the disclosure of the names of the parties' joint research agreement. Purpose of paragraph 2 of the joint research agreement means written contract, grant, cooperative agreement entered into two or more persons that needs performance experimental development and research work in field of claimed invention. Title 35 U.S. Standard Code 104, repeal. Title 35 U.S. Standard Code 104, inventions made abroad. In general, proceed with the patent trademark office before any of the component authority applicant with the patentee with the may not establishment with the invention reference with the knowledge thereof with the other activity with respect thereof with the foreign country with the non-NAFTA country or WTO member country has provided in section 119.365 rights inventions was made by a person civil or military wide domicile in the United States, serving the other country with a connection with the operation on the behalf of the United States, domicile with the NAFTA country, with serving another country connection with the operation with the behalf of the NAFTA country, domicile with the WTO member country, serving another country with the operation on the behalf of the WTO member country, with the persons with the entitled to the same rights with the priority of the United States with respect to the invention. Such invention has been with the United States and NAFTA country, WTO member in the case of the maybe. Use of information, consent of the information after the country of the WTO member country concerned with the knowledge or use for the other activity relevant to prove the disprove of the data invention has made available to you for the proceeding with the patent trademark of the country for the other component authority. Same extent of the information could be made available to the United States with the district court with the other authority shall be drawn with appropriate interference for the take other permitted of the statute rule regulation in favor of party of the requested information proceeding. B. Definition as used in the section term NAFTA country may mean given in section 2.4 of the North American Free Trade Agreement Implementation Act. The WTO member country means the given term of section 210 Bulgaria Round Agreements Act. Title 35 U.S. Standard Code 105. Inventions in outer space. Invention made either the soul of the outer space object component thereof with the jurisdiction control of the United States can be considered to be made, used, sold in the United States for the purpose of the title. Similarly, respecting space object component thereof is specifically identified otherwise provided for in an international agreement in the United States is departed with the respect to space object component thereof with the carried on and registry of the foreign state in accordance with the convention of registration of objects that launch into outer space. B. An invention made, used, or sold in outer space on space object component that is carried on registry of the foreign state in accordance with the convention of the registration of objects launched into outer space shall be considered made, used, and sold by the United States for the purpose of the title specified the scope of agreed in an international agreement between the United States and state registry. Chapter 11, Application for Patent.